I'm good. If you're
Okay. So good evening and welcome to the Town of Norfolk Planning Board meeting on Tuesday, August 17th, 2021. Let me introduce our members. To my left, John Weddleton. To my right, Gary Searle, Chad Peck, Chris Montfort, and Gary Sullivan, our associate member. Also with us this evening is Richard McCarthy, our town planner. This evening, this is a meeting face-to-face here in the town hall, but also a hybrid meeting in the sense that there are participants who are with us on Zoom. And so please be aware that the meeting is being recorded, both audio and video, and that some attendees are participating by video conference. And please be aware that other folks may be able to see you, and take care not to screen share your computer if you're out there. Anything you broadcast may be captured on the recording. So with that introduction, let us begin. Our first item on the agenda this evening is 7 Hill Street special permit pursuant to zoning bylaw section H3, affordable housing development, continued from July 15th. Sir.
Good evening, Mr. Chairman and members. Attorney Lewis Peck on behalf of the developer. I have been authorized to come tonight. They've opted to just participate and watch the proceedings. When we were here last a month ago, we discussed at some degree of length the applicability of the pending changes to H3. We had applied for a special permit through you, the special permitting authority, for a determination of the number of affordable units or payments in lieu of the number of affordable units that were going to be required for our project on Hill Street. Solicited in advance of that meeting an opinion from your town council concerning the applicability or possible applicability of the pending changes. I understand those changes were both not only adopted by town meeting, but have now been approved for inclusion by the Attorney General. A recent correspondence shared by Mr. McCarthy indicates that they're now part of your zoning code. So our position remains the same. We argued on a number of fronts last time to you that we believed the provisions of the old H3 bylaw were in play, that would result in a determination of one affordable unit or a calculation of a payment equivalent to that. Your town council authored an opinion letter that took a different position, namely that the new H3 provisions would be in play, and that, as we understand it, would probably result in a determination that 3 units would need to be dedicated or payments in lieu thereof. Again, I don't think our position has changed. The clear language of the provisions of Chapter 40A, Section 6, the so-called zoning freeze statute, in our mind is clearly applicable here. That language clearly states that special permits that are granted and in place are not subject to zoning changes that occur thereafter. There are a number of cases, although not directly on point, that persuade us that there's considerable authority for the determination that supports our position. And as such, I'm here to reiterate those arguments if you want me to. I think I went into them at great length last time. The board, through the chair, expressed some reluctance to come to a determination that's supportive of our position. You took sort of a straw poll, not a formal vote, of course, but your members seemed to indicate to us last time that without a contrary opinion, you probably couldn't give us the relief that we're looking for. Among the things that we explored over the last month was the possibility of getting another attorney to look into this, special counsel. That process would necessitate an approval from the selectmen to go out and get special counsel. That would incur cost on my client's behalf. That would probably result in a delay of many, many months. And given the posture with regard to this project, we simply can't go that direction. You probably remember that we're under agreement to sell this project to a builder. And without a favorable determination, namely that the old H3 applies, that deal is probably going to be lost. And we would be left to either explore alternative uses of this property, uses that are allowable as a matter of right or something along those lines, and/or seek a judicial determination that supports our position. So I was charged and tasked with in the last month to make ready for court. And I'm not saying this as any sort of a threat, but you can understand our position is a very substantial one in terms of the financial impact that the decision that you make is going to have on us. And we are poised and ready to submit to the land court permit session a complaint for declaratory judgment that asks the court to look into this and to make an adjudication that the old H3 applies. So I would respectfully request that, we reach some measure of closure tonight if we can. I'd ask if you're going to vote, and I would hope that you would find it possible to vote favorably and give us a special permit saying that one unit is allowable. If you feel that you can't, we are going to be left to our devices, so-called, and we're probably going to institute suit and simultaneously track the development of the property in a different direction.
You mentioned earlier in your conversation that pursuing a second attorney, as we were originally going to explore, would take some time. Well, certainly going through a suit is going to take you some time, and going down a direction of redeveloping the property in a different format with a different purpose, whatever, that's going to take you a lot of time and a lot of cost. So it seems to me that the exploration of this alternative attorney would be the most expeditious way to get another ruling, someone who is really an expert in this zoning field.
I can absolutely appreciate, Mr. Chairman, your thoughts in that regard, and we thought about that long and hard, and we came to the inevitable conclusion that if we go down that route, it's going to take a number of months. We're going to lose our prospective buyer now. We're going to incur costs, and if that special counsel doesn't side with us, we'll be left with the need to go back to the so-called drawing table anyway.
Sure, that's true, but...
So that's going to cost us a number of months, and it's going to cost us some money. And we just felt it to be the efficient use of our available time, to get this in. And also, the court that we're going to go to, the land court, has a special session called the permitting session. There was an act passed, I think in 2016, that authorized the land court to create a special session that hears permitting questions on an expedited basis. So the last time I was in that, it's very rare to get the opportunity to go because it's very limited jurisdiction. But the last time I was there, we were in and out of that court in 6 weeks. Once a case is filed, it's served, the responsive pleadings are entered, you're immediately called in for a status conference with the court. And we literally had a dispositive hearing in a matter of 5 weeks and a decision within 6 weeks the last time we were there. So we're frankly quite hopeful that we can get through court very quickly. And we don't want to spin our wheels needlessly, but, we've got a pretty substantial project here that's hanging in the balance.
Well, it strikes me that sounds like an expeditious route, which would be equivalent to what we would see if we went to this other attorney. I can't see a finding from this attorney taking months, as you suggested. I think it would take weeks and at best, if not days. But anyway, that's...
But then we'd have to convince, his opinion is only an opinion. We'd have to convince you to adopt it. I can't be assured of that. And I'm giving this board the respect it deserves. You've got the right to independently look at that opinion if it comes in. If it's contrary to the one that Mr. Mello drafted, you members may be in a position where you don't want to accept it.
Understood, okay. Thoughts from the board members?
Follow-up question on something you said. I understand that state law says that if a special permit hearing has been closed, even though it's not voted on, it locks in that law at that time, and any new bylaw changes aren't applicable. I understand that, we've been through it before. The hybrid of this matter is, this filing had a special permit for site plan, and then we had contingent permits, stormwater and affordable housing, based on that mother permit. Which has always been my issue, how can you have 3 special permits in one filing with different bylaws? Right, when you say that the special permit hearing was done and locked in, the special permit hearing for the affordable right was not opened at that time. So how do you respond to that?
I'm happy to, John, thank you.
Right.
The mother permit, as you call it, and that's actually probably an adequate, accurate rather, thing to call it, did tell us that we needed to go get a special permit under H3. Our position is that we were obligated to go get a special permit under H3 as listed at the time. Chapter 40A, Section 6 says that once a special permit is granted, the law in effect at the time, the municipal zoning code in effect at the time, every letter, comma, period in that zoning bylaw is the law that applies to our project going forward. Changes do not apply to us, and that's called the zoning freeze, and it's there for a reason. It protects developers when they design projects, when they come seek permits for projects, and when they build projects. And the zoning freeze language and all the cases that interpret that statutory section say the developer has to be protected. You can't let a developer spend a lot of money and time designing a project, getting permits for a project, and starting construction, and then change the rules of the game. So our simple interpretation of this scenario is that even though the affordable housing permit had yet to be applied for or received, the project was designed with one affordable unit being the number of units that we were going to need to dedicate to affordability or to make payments in lieu thereof. Had we known that we could be potentially subject to changes in that number of units, we may have designed the project differently.
I mean, on that note, we didn't keep the zoning changes secret. They were published out there for review. There was the B1 zoning committee, then there was the citizens' position.
That's correct.
We had many meetings about that. There was
Correct.
ample
We're not saying
opportunities
that
for you to open up.
You violated the law in any respect in terms of changing H3. Yeah, you went through absolutely all the required statutory procedures.
But the point being is that there was ample time for you to come in under the regular bylaws. It was written to open up that special permit hearing at that time.
I understand, okay, that's a different point, thank you for clarifying. And again, we didn't know that we didn't have all the adequate permits in place until we had this property under agreement, and our potential buyer came to town hall making inquiries about the status of the permit, and that's when we found out that we needed to come back to you. So we immediately applied and asked that a permit under H3 be granted for one affordable unit. The problem is, the town had already published notice of the pendency of town meeting and the proposed changes. And as the law is worded, there are a number of municipal statutes, I don't remember the chapters and numbers off the top of my head, but once the town publishes public notice of your town meeting warrant, we're stuck with those changes if they apply.
If they're voted in.
If they're voted in and they apply.
What complicates the matter is that when this process was going through the approval process, special permit for the multiple housing, the affordable housing bylaw had no limit on the time to file.
Right.
We had just finished up Norway Farms, which probably filed well over 2 years after it was done. He had actually started construction on the roadway and was right well into it. So that always been the process before. And when the draft approval was sent to the applicant, it did not mention a time period on the affordable permit being done. So it's all really kind of muddled up. After reviewing again the lawyer's information, the studies that he gave, I think Rich said he really actually concurred after the fact, were not case studies that are applicable to this case. They were not case studies where you've got one mother permit that all has these secondary permits that are all based only on the main permit. They are all separate permits filed separately, independent of the main one. That's what makes those case studies, in my opinion, and he did concur that they really weren't
Yeah, it wasn't exactly on
Right.
point to what we're talking
So
about.
basically, I have a letter from a lawyer, and I've got no case law, because I don't think this has ever happened.
Right.
So we stand with the situation of this never being happened, and well, we're not a precedent-setting board, so this really wouldn't set a precedent for future actions, but it just looks into the whole thing as something I think our board really has to think through and decide what's equitable. That was my position last time, anyways. I'm
I mean,
probably
it kind of seems like
repeating
it's been a
myself.
clerical error,
Right,
right? I mean, we knew these changes were coming. We didn't do any due diligence on our
Right.
half to say, hey, what's out there that might
And
be.
what complicates it a second time, and I think I might have been chairing the board when some of this happened, right? He went for renewals on that special permit.
You
for-
did, yeah.
2 or 3.
Yeah.
Nothing was said. So you get into dirty water to start, and it keeps getting cloudier and more cloudy because of all of the confluence of everything that happened. Like I said, I think we've got a first here because no one could find any case law with this same thing.
And just to amplify Mr. Weddleton's comment, you know, we were here twice for extensions and once
Yeah, I
for a
remember.
modification,
Yeah. I was associate at that time.
which were duly, you know, published and noticed, and public hearings were held, and Mr. Weddleton also indicates that he's dug a little bit deeper into your attorney's memoranda and the citation of cases. I absolutely agree that there is not precedential value in those cases. He felt like he needed to take a position and try to support it, and he did, and that's fine. However, he really should have noted in his memorandum that those cases don't have clear-cut precedential value. Those are cases that are much different.
Subsequently, he did admit that, and I got that information through Rich. So at least we're all on the same
Yeah.
page as
So,
far as the case.
you know, we're in a very unique circumstance. And you do have the ability to set precedent, and my hope is that nobody else is in the same posture as us, that they applied for, got a special permit, and then, oops, all of a sudden, they didn't get an H3 permit, and now we're 2 years downstream.
Yeah, I believe I asked at the last meeting if there was any other cases and you mentioned this was a singular issue.
Yeah.
And we would very much like to do this project and build, it's a good project, and we would very much like to get a ruling from you that one affordable unit is allowed, or a payment in lieu, and to move on from this. We don't want to go a different direction, but you can understand the financial constraints we might be under, and they're for real.
All right, so let me just ask, in what basis, is the board prepared to take a vote this evening to Mr. Caravaggio's request to either uphold the 3 or the 1 affordable, which we could do. We could take a vote this evening, which would at least settle the matter from the board's point of view, and allow you either to go forward with your project and sell it as is, or proceed down the process of going to court as you're talking about.
Don't we really have to make a vote, Walter, because there's no other information that's coming to
Yeah,
us? Right?
But I don't think there is, John, unless,
Or we make a motion to defer, like we had talked about, to get a special council opinion.
Decided
But the-
close.
Yeah, but we've respectfully declined that option.
Okay.
And there's been no other discussion with the attorney aside from Rich and the attorney talking about the cases. The attorney's opinion remains the same.
It's the same, yeah. There hasn't been any subsequent conversations about
And
it.
he used that exact language. He mentioned opinion in it.
Oh, yeah, and yes, there is his opinion.
Rich, is this vote a majority vote?
Supermajority, so 4 out of 5.
Do you need to ask for anyone that's,
yeah, I suppose we could.
So, just for clarifying,
Not on the Zoom. just
not
in
on
person.
Zoom, because.
not on the Zoom?
Not on the Zoom. So, for public hearing matters, they need to either have written comments or be present to give their comments.
Okay.
For general matters that are under the open meeting law, your general business, absolutely open to the public
Okay.
through Zoom.
So just thinking ahead,
Mhm.
if we have a vote to approve 3 units, right, and there's not 4 votes, do we go back then and have another vote for a 1 unit? And what if there is not 4 votes on 1 unit? What if we're locked? Right?
I think if we're locked, you go to court. I
If
think
it's
that
less-
seems to
Well,
be-
doesn't our previous vote from the last meeting?
Well, I don't think we voted last week.
No, we didn't.
No,
just-
you didn't vote.
We
Straw
asserted,
poll of sorts. Mr.
Yeah,
Byron
it
was
was just
asking
a-
people's opinion.
yeah, it was just a.
So the one thing, as you know, I know you've requested a vote tonight from your applicant. I mean, the board technically doesn't have to vote tonight. You could close the hearing and then you got 90 days to render a decision, as you know.
Is this,
Special
is this a
permit.
formal hearing?
Oh, yeah.
Yes.
Yeah.
I thought it was just a discussion.
No, this is a published,
Did we read this into the?
you did the last
minutes?
meeting, so it
continuance, yeah.
opened, yeah, it was a
Last
July
one we did,
15th
yeah,
meeting.
right, okay.
I'm not suggesting that necessarily, but you could, of course, if you close the public hearing and new information comes in, then, yeah.
So what
The
are our-
risk that I run if you do that is I have to convince a judge that is ripe for adjudication.
Yeah.
So I've got some things up my sleeve and under the declaratory judgment statute that allows him or her to entertain the question, but I'll have some additional, I'd much rather go in with, well, obviously I'd prefer a favorable vote. But if I can't, then the next best thing for me is an unfavorable vote, so I can then go and tell a judge, I got a ruling I didn't like.
It's kind of interesting, if I were to list those and cons on this particular matter. That's zoned residential commercial, so.
Yeah, it is, yeah.
Right, if we deny it, we have court fees, which are in the middle of this, Mr. Petrosi. The applicant has the obligation to 40B it, and this 2-acre parcel here that was started, same 2-acre parcel at the Bork's Restaurant on Main Street, that initial building was 40B with 70 units, correct? So you get the potential to have 70 units there or a commercial building. So, and in the, if we vote in favor of the 3, we have 2 more affordable units.
Not necessarily, because at that point,
Yeah,
they
not
might choose
necessarily,
not
because
to.
I could win in court.
Yeah, that's our best outcome, having 2 units.
Three,
Is
Yeah,
your-
2 extra.
two extra.
Is your client offering anything in between the one, you're trying to
So-
convince 5 people here? Did you come in to just say
I
we're
would
still sticking to
love,
one?
I would love,
No,
because
could you do
that's
that,
my
Gary?
forte is negotiating, but I don't think we can negotiate
I mean, it's
this.
either, we either interpret the bylaw.
I think in this case, you're kind of locked in. It's either.
This is a black
Either
and white
one or
issue.
three.
I'm
Yeah,
putting-
that's-
It's
it's-
negotiating.
It really comes down to is, do we interpret it as the mother special permit?
There you go.
It's what it comes down to is.
I understand.
Is the mother special
Well,
permit control it all? Or does the special permit that was applied for the housing, which was after the changes,
Exactly.
which one
Exactly.
takes effect?
Exactly.
The mother permit or the H3 special permit later, that came in
Exactly.
later?
I agree.
I mean, that's what we're voting on.
That's
And
it.
Yeah, and so we, the only reference we have,
Is the
other than
attorney.
ourselves and our own opinion, is town council. We asked him, and he gave us an opinion, and he said that the new law applies, so.
But his opinion didn't have this, it's my understanding, right, that his opinion didn't have any reference or case studies that had this special mother permit, right?
Correct.
Right, there wasn't a,
Right, so there was no direct apple-to-apple comparison that he could find.
no, he was trying to cite a case to give some context to his opinion, but there isn't a case on point that I know of.
That fact doesn't make him wrong.
But even without the
Because there's no
case
case to cite.
references,
Right.
he offered an opinion,
Yes.
right?
Yeah, absolutely,
Right.
yep.
This would be the first time that you had a site plan that involved 2 different sets of bylaws. Same site plan.
Yeah.
Right.
And just think of
Right.
the fairness question. As you deliberate, I just simply ask you to consider the fairness question. Developed, it's had a relative standing relationship with the town, has done work. And last time, at the last meeting, it stood up and spoke gloomily about this developer. So, for whatever that's worth.
That because he named a street after him.
Yeah, clever.
We'll put that aside.
Okay.
So 5 more streets and he's got this, right?
I can offer you a sidewalk.
I don't want to get
All right, so,
Right here.
your opinion, sir, are you prepared to take a vote tonight?
Yes.
Are you prepared to take a vote tonight?
It sounds like we need to take a vote tonight.
Right.
It sounds like we need to make a decision on, does the master plan take precedence? Or does the H3 special permit take precedence because it was filed later? I think we need to. It sounds like we gotta make a decision.
Okay, fair enough.
So,
And,
yes.
are you prepared to take a?
I am. I think of the merits of both sides of this, and I also think of who's really being harmed here, and the fairness question as well. So I can take a vote for this.
Okay.
Sure.
Sir?
I look at this, it's fairness on both sides. It's fairness to the applicant, what's best for our town, and what's best for the neighbors. Right? This happens to be a very good project. It's well designed, it's well laid out. It fits the neighborhood and the alternative, and not that I know the applicant that much, but could that be a 70-unit 40B? Without a doubt. Right? Could that be a commercial building? Without a doubt. So for the sake of the 2 extra units and the legal money spent, it adds another one to our pile. What's best for everybody involved? What serves the best purpose? Because I don't think we're under any case law ruling that we really have to go by. We're gonna sort of make our own decision based on what we think is right and fair. So,
Okay,
Yeah.
thank you, John. All right, well, I'm prepared to entertain a motion.
Wait, before you do that. So Rich, just want to confirm, there's no other special permits out there that would fall under this
Any
type
other
of situation?
residential development? No, the only other one, which is already under it, which was Norway Farms. We don't have any,
Okay.
we don't have any previously approved residential projects that are subject to this bylaw.
Okay, so from a procedural point of view, Rich, let me offer a suggestion that we vote on 3 and see where that goes, and if it's rejected, then we vote on 1, as John suggested earlier.
I probably would suggest the reverse, only because he applied for the reverse.
I applied for the reverse.
You applied for 1, you know, so you should vote on.
Well, if you vote on 1 and it passes, then the other vote is
Yeah,
moot, and you don't even take it.
right,
Right.
so my suggestion would be you take it's either yes or no on the.
Okay, fair enough, yeah. All right, so Chair will entertain a motion to accept 1 affordable unit for the project at 7 Hill Street.
so moved.
We have a second, All
Let's
right.
do a roll call vote.
We will do a roll call vote, yes. All right, start with Mr. Montfort, am I right?
Aye.
Mr. Peck?
Aye.
Mr. Searle?
Aye.
Mr. Weddleton?
Aye.
Chair votes aye, you got your 1 unit.
Gentlemen, thank you so much.
Actually, you know what? That was good.
What now?
I got caught up in we should close the public hearing and then vote. Could you do a redo? My apologies. I'm doing 2 things at once here, so,
Well, for heaven's sakes.
sorry, my
To
apologies.
close the hearing.
Second.
Motion to
All
close the
right,
public hearing.
motions
My
have been
apologies.
made and seconded to close the public hearing. All those in favor say aye.
Aye.
All right.
All right, now Chair will entertain a motion to accept 1 affordable unit for the project, the housing project at 7 Hill Street. Mr. Montfort,
Aye.
Mr. Peck,
Aye.
Mr. Searle,
Aye.
Mr. Weddleton.
Aye.
Chair votes aye.
And I reiterate my thanks. This was not an easy one. I appreciate you spending the extra time to deliberate it.
Okay.
I think we're good.
Yeah, we just have to draft the decision. that's all.
Okay.
Thanks.
Now, what we want to know is, what are you going to name that little street? That's what we
Call
want.
it Byron Way.
No, don't do that.
All right, have a good night.
Yeah, okay.
Thank you.
All right, so the next item on the agenda is,
228 Dedham Street,
Yeah.
request for
Continuance?
continuance until 14th of September. So Chair will entertain a motion to continue the site plan special permit management application.
So moved.
Is a public hearing, is that right, Rich?
Yes.
This is a public.
Yes,
So
yes.
we'll entertain a motion to continue the public hearing until September 14th
So moved.
at 7 PM, right? That's the first one, I believe.
yeah,
Okay.
that works.
Do we have a second?
Second.
All in favor, say aye.
Aye.
It is a vote to continue that. Next item, review Willow Place A&R plan, approval not required plan.
So I think,
let Rich start first. Go ahead,
I
Rich.
think one of the confusing parts for sure, the last time the plan was before you was that, so I'll just speak to the
Yeah, okay.
exhibit on the screen.
Yep,
The parcel is a significantly large parcel, so what you actually saw on the A&R plan was just this small section of the property, which, so you didn't see it go all the way over and have frontage on Baltimore Street.
yep.
So I think that at least probably creates some confusion. So parcel A is really, is being deeded to the trust for, what? The Greaves, sorry. It's in relation to a land dispute that's been going on, so that's a settlement.
What lines are being combined with?
So there's this
Yellow?
little teeny little piece right here. that You
Right.
see, I'll go to the next one and then shrink it down, you'll see it better. So this little piece right here
Yeah,
on Willow Place
They're combining that.
is combined. They're not combining it at this time. The first purpose is to settle this dispute matter,
right.
and we'll go to the Greaves Trust. And then they'll either do nothing with it, just keep it as a parcel in the two parcels, or then maybe they entertain something down the road. But that's really step two.
Right, now, step two, just to continue with step two, my understanding is that there's insufficient frontage on this
That's correct.
It
road.
would have enough for if they wanted to combine it for an estate lot.
For an
Yeah,
estate,
but that's retrospect.
yeah, okay, all right.
My issue still is the same. Parcel A, that you want to do an independent A&R plan for, does not stand in the merits of state law with its own frontage. If they want to combine that with that little nab in the front that has frontage, the whole thing, they should either just combine it without the need for the planning board to come in, or combine the two as a Form A lot. Or what we're doing is creating a Form A lot that's abutting something that may be owned by them, and it does not meet state requirements. So that's what I said before, Jim. You could combine this with that little parcel, and you don't need us, you do it right all the time, or you make them together, and together is one Form A. Right now, you meet the state law requirement for the frontage. But you
For an
you
estate
can't,
lot.
right, you can't have it this way. And you certainly can't have it this way, saying that, all right, I'm gonna do an estate lot down the road, which means it's 50 feet, which really leads me to believe, why would you do an estate lot only needing 50 feet when combining them, you have the frontage? What's that all about? Right, why are you doing that?
Well, we wouldn't have the frontage in that zone. You know, if we combine them,
You wouldn't or you would?
we would not.
You still wouldn't have the frontage.
No,
Right.
no, that's why, if we grab this piece that they've been disputing over a number of years
Yeah.
with the Upland Game Club, if we take that and later on come in for a special permit, we could produce an estate lot. You know, we would have enough.
Here, but we're here to sign an A&R plan.
Correct.
An A&R plan that he just outlined does not meet the state requirements for an A&R plan. That's what I was hopping on last time, and maybe I'm missing something, but I don't think so. So
Well,
signing that parcel on its own, I don't care about what the future holds, there's no frontage on that parcel. And there's not many things required for an A&R, doesn't have to be buildable, it can be loaded with wetlands, whatever. But it does have to have minimum frontage for the zone, right, and this doesn't have it.
So the challenge, and I get the complexity of it, but they're creating a non-buildable parcel
I understand,
by doing that.
I understand.
And the lot already does
For-
have
for-
frontage on Baltimore Street.
Again, we're signing a plan with that red line parcel A as an A&R plan, and it does not meet the law.
Oh, it does meet,
Where's the frontage on the parcel A?
not on the front parcel, on the mother lot.
Yeah, but we're not signing an A&R plan for the mother lot. We're signing an A&R plan just for parcel A.
Well, parcel A is coming from
Right.
the mother lot.
But that doesn't matter. It doesn't matter. If we're signing an A&R plan, it's gonna have frontage. So he either combines the two to show the frontage, right, or he doesn't, but we don't have any legal authority to sign something without frontage.
But didn't we,
You're
Is
not.
there some objection to combining the two?
no, no,
Well,
But he
there
just
is
said
in
if you
terms
combine them,
of,
it's still not gonna have
Well,
frontage, he said.
there is an objection in terms of the process. So they're trying to, Mellon, the trustee for the Mellon estate, is trying to resolve this land dispute. And their fiduciary is just to settle this land dispute, which is that the trustees for Bar Degrees would get this parcel A, which was a dispute between Upland Game and Fish.
And that's fine.
And they can settle that dispute, that's not a
Okay.
problem.
That's fine.
But to throw in a Form A is a whole different thing. It's not
Right.
just,
But they don't have, even if they combine these two parcels, they don't have the required frontage.
that we shouldn't be
For
here.
an estate lot, they do, don't they?
For the state lot, yes.
So they need to combine it and apply for an estate lot.
Exactly. Exactly.
So
That don't,
Exactly.
I think,
no?
I'm not gonna convince, I don't think I'm gonna convince you otherwise. You can create a parcel that's non-buildable with a Form A.
yes.
It happens all the time. It's not, it's not,
But you just said the Form A parcel, right, if that's the one they're combining with, doesn't have legal frontage.
but you're creating a parcel of land off a parcel that has frontage already. It's the,
What am I missing? You
this
just said,
lot. This lot had frontage on Baltimore Street.
which lot?
The
This
big-
lot,
the big
that
yellow lot.
red
Yeah,
parcel is coming out of the yellow. That's the parcel. What is it, 100 and some acres?
Right.
It's just over, it's 100, it's like 106 right now. The Upland Game needs at least 100 to maintain their
You wanna buy
status.
10,000 square feet off of me,
That's right.
okay? You create a non-buildable parcel on it, right? And then you convey it to me,
right.
okay? And then I can file a perimeter plan and erase that interior line and record that lot
Sure can.
on record.
But in the meantime, when you transfer the lot, if you want an A&R jurisdiction, which is state law, that doesn't meet the requirements. So they can do anything they want, they can combine, they can separate, they can do whatever, but we don't have the authority to sign it as an A&R plan because it does not have the legal state frontage. Correct. They're cutting off something that does, but what they're creating now does not.
Well, I'm gonna respectfully disagree.
All right,
Thank
that's
you.
fine.
But
Yeah, because let's say I'm a developer, think outside the box, and I understand. Like we're saying, I can cut off 10 acres of my land, and just keep it as 10 acres and call it a non-buildable lot.
Yes, you can. Yes,
And
you
keep
can.
it at that.
Right, yes, you
Okay,
can.
and now I have two lots.
Right.
Yep.
And that's
exactly.
what I'm doing, and that's
But-
what
but
I'm
you want us
basically
to sign
doing.
it as an A&R plan. And this
Approval
is-
not
there's-
required though.
There are state requirements to sign something as an A&R plan.
Right, I
And
understand
this
that.
does, and this parcel that you're breaking off doesn't meet the state requirements.
It doesn't need frontage. It does, because, John, let's say all right, we have 10 acres on the street, okay? We put a 50-foot right-of-way in there. That back piece doesn't have legal frontage, but we sign it
So,
and we keep that a parcel.
right, you can, absolutely. I'm
So
not
this is
disagreeing
the
with that.
same thing.
Well, it seems to me that at this point, there are two things required. One, you ought to complete this transaction and register that as a non-buildable lot, and then combine it with a little piece up front and come
Right.
back to us and apply for an estate lot.
That's correct. But the problem is, the trust is not in a position to develop. They are trying to solve this argument between Upland Game and the Greaves Trust, okay? In putting this 6 acres cutting this 6 acres away, that would, that would, you know, give the 6 acres to the Greaves Company, and then the upland game, and the dispute would go away.
Well, it seems to me from what I've heard from my colleagues and from Rich, and even from you, is you can do that without requiring us to sign an A&R plan.
I probably could, I probably could. I could probably say, I could probably go ahead and just agree on a line,
Yeah,
okay, between the two parties
right?
and record the plan.
Yes, agreed, agreed. And then if you wish to, you could come back, combine the two pieces, and apply for an estate lot to make that a buildable lot down the road, which you may or may not want to do, but you could do it.
Correct, yep. All right.
So it seems to me that's the appropriate sequence of events.
But would probably, and I discussed this at length with the attorney representing
Correct.
The owner.
With Deb.
with Deb, who,
Deborah.
and even the fiduciary for
Yeah.
Ellen.
Yep.
Yeah,
And they don't have any interest in doing it that way, so I think perhaps maybe they should appear before you.
Maybe we should just ask our town council, because I don't think this is really an involved question, right? Rather than coming into, they're doing all of this maneuvering for a reason. I'm not really sure what it is, but rather than just separating a parcel or whatever, this extra step is for a reason. I don't know what it is, but I do believe, and I could be wrong, that's why when we went through this a meeting ago, I asked to get this referred to town council, because to me, it's really kind of a simple matter, but, right, I guess that hasn't been done. We certainly don't want to just take the advice from the applicant's or attorney, that's all.
So is this considered a transfer between two parties?
It is, from Upland Fish and Game to,
According to the Mass law for A&R plans, an A&R plan must have frontage on an existing public way, except in the case of land transfer between parties. Because I wanted to look it up. I had no idea. I didn't realize there was an exception there. So if this is a transfer between two parties, then then the frontage doesn't matter.
Is that what that means?
That's what it's, yeah. It says all lots shown on an A&R plan must have frontage on an existing public way, except in the case of a land transfer between parties.
well, it's better stated than the way I said it, so.
We knew what you meant.
Just have to confirm it.
So if this is a land transfer between parties, then
That's what it is.
it doesn't have to have frontage. And it still qualifies as an A&R.
I was
that's
trying to-
interesting.
So we don't need town council, we have our own.
I Googled it.
Well, with all due respect, Chad, I think we should bounce it off town council.
That's fine.
Yeah,
Yep.
So
I think
if,
John's request is reasonable.
yeah, so in terms of timing, if you would just, we would need extension. Because it's the 21 days will pass before we can get to the meeting,
Okay,
the planning board. If the applicant would
yeah, it will.
request the extension, so I could just review it with town
Okay,
and then place it on the September 14th meeting.
You know, the fact of the matter is, if this is an A&R plan by law, right, we only have 30 days to approve it. If not, it automatically becomes approved.
The 21.
That's right.
It's-
It's-
How many?
21.
21.
It hasn't the 21 expired already?
No,
No,
Oh, it hasn't?
no, this is just a file, so it's just not enough time to get to the next planning board meeting.
So the applicant would have to agree to an extension.
Extension, yeah. We generally like to settle these matters, not get it automatic, and then the clerk has to
Yeah,
sign.
yeah, agreed. I would prefer not to do it that way, yeah.
yes,
I think you can get that at your client, right?
yes, yeah,
All right.
I can,
If you guys are comfortable with the way it is, I'm not gonna hold it.
Well, no, I appreciate what Chad did by looking it up. On the other hand, I would prefer to have town council read that, or read something in addition to that, that Shad might have, not have uncovered, and give us his opinion before we vote.
Okay,
It's fine, yep.
fair enough.
Okay.
That's fine. Just confirm is good.
I'm sorry we couldn't resolve it this evening, but I think we've got the steps in place to be able to resolve it for you
Oh,
at our
thank
next
you.
meeting.
So you just
Thank
vote, yeah, just vote to place
To
on.
continue.
Continue it.
This wasn't a public hearing, was it?
No,
Yeah.
just, we'll,
But we need to vote to.
just vote to place it on the.
Yeah, all right, so Chair will entertain a motion to review Willow Place A&R plan at our next meeting on September 14th at 7:15 PM.
So moved.
Second?
Second.
All in favor, say aye.
Aye.
All right, sorry we couldn't resolve it this evening, but we'll get there.
Thank you to the board. Thank you.
Our next item on our agenda is 32 Frederickson Road, request for extension of a state lot special permit decision 2019-08 to September 10th, 2022.
So on
Rich?
this, I need to recuse myself as a resident of Frederickson.
Okay, fair enough, yep.
So Mr. Cataldo is here. He did purchase the property, excuse me.
From
for the-
Mr. Morse?
Correct.
Yeah, okay.
For Mr. Morris. They're working their way towards getting a building permit, so I just wanted to just be mindful of the timeframes, just to be sure he's got everything covered. So he's requesting an extension, which can be done by the board administratively. So that's what he's here before you to request.
All right, so
Extension of the special
we have, the board has extended this once before, have we not?
Yeah, it has been extended
When Mr. Morse?
probably
A few times.
at least 2 times, I
At
think.
least 2 times,
Yeah.
yeah.
Well, at least at this point, it was sold. They're working on their building permit to construct their home. And it's really just to be sure that there's no hiccups and then the thing lapses, so.
Okay.
The board can do that administratively, and that's what
Sure.
the request is.
All right, any discussion by board members? All right, Chair will entertain a motion to extend the state lot special permit decision 2019-08 to September 10th, 2022.
So moved.
We have a second.
Second.
All in favor, say aye. Aye. You're all set.
Thank you. It's the last time you have to extend it, promise.
Let's hope so, right. Good luck with your new home.
Thank you.
Okay, next item on our agenda is Fern Ridge Estates request for bond reduction. Rich, you want to take us through that one?
So Mr. Petrosi had requested the last planning board meeting a bond reduction for Fern Ridge Estates. The board referred it out to Beta Group to do an inspection. As-built plan was provided to the board, which was reviewed, and then a site inspection was done to look at the level of completion of the project. And you have for you a report of their site visit, what they found, and then a cost to complete reduction, which amounted, the dollar amount of $11,000.
12,100, wasn't it?
Yep. 12,100.
12,000. Yeah, so 12, sorry, I'll go back to
It was
12,100.
11,000 and contingency at 1,100. Yep.
Correct, yep.
Yep.
So,
So,
that being the case, there is a recommendation to reduce the bond
to that amount,
which is
okay.
12,100.
And it's from 28,200, is that
22,406.
22,406, okay. All right, discussion by board members before we take a vote?
I have no problem with that.
Okay.
Straightforward.
Okay, Chair will entertain a motion to reduce the bond for Fern Ridge Estates from $22,406 to $12,100. Do we have a second? Do we have a motion, excuse me?
So moved.
So moved. Do we have a second?
Second.
All in favor, say aye.
Aye.
Opposed? It is a unanimous vote. Chair votes aye. Okay, next item on the agenda, Hills End Farms, Fox Run Subdivision, update on the drain line repairs with Polti Homes. Sir?
So, as I put in the packet, we finally have reached consensus how to approach corrective measures on the remaining drainage to have that lined. The work should actually probably get started within the next few weeks. So I just put it on the board's attention for the, just to close it out for now. Once the work gets done, they'll have to provide the videos, inspections will be done of the work by DPW and the Beta Group, hopefully prevailing that everything looks good. We do need to square away the final bond language, though, so I'll be working on that
Okay.
as well,
Yeah.
which is the replacement bond for the $100,000, and then we'll get back out there to take a look at the work, and there are going to be video on the work that had previously been done with the lining, and then if everything seems to be in order, then the goal will be to get it accepted next fall.
I'd just like to note that there was considerable effort on the part of members of the board and Rich, as well as Polti, to finally negotiate this agreement, which went back and forth a number of times until everyone was comfortable that all the Ts were crossed and the Is were dotted, and we got all the signatures. But it's in place. I think it's a solid agreement. It's right for the town, and as Rich said, if we follow through with the inspections of the lining on the drain lines, we should be in good shape down the road. So cross our fingers that it all comes out the way we hope it does.
Yeah, absolutely, agree. Appreciate all the support and the work from the board.
And
on
I
that.
see Blair's with us, and he probably agrees as well.
Yes, it's been a long time coming. I'm glad that it's finally the light at the end of the tunnel is here.
Okay, thanks, Blair. All right, let's see, request to release lot 5 and 9, is that right? 5 and 9, Norway Farms Drive. Affordable housing funds have been received. Rich, go ahead.
I think it's only one lot, though. Lot 5, number 9.
Yeah, lot 5,
Number 9.
number 9, Norway Farms Drive. So
Ah.
that is in your,
All right,
so that is in your packet
yeah,
in terms of, to get that signed, then Betsy will come in, notarize it. Then there's a couple other matters. I do have Elizabeth Maitland on Zoom, and Rob Kane, I don't see, well, it's a little dark. Can't see
I'm here.
Rob too well.
he's hiding in the dark, yeah, but he's there.
All right. Both of them there. So
There we go. Whoop.
Good evening,
that would be
gentlemen.
your devices.
That's you, Rich.
I think it's
Your lap. They're right
the
behind the
speakers
TV
behind
screen.
the.
Speakers
Oh,
behind
behind
the monitor.
To your right, and on the other.
Stand up,
to your- nope,
stand up, stand up,
on the other side of
look
your
over the
screen.
monitor.
No. That was all.
Something over there, though.
It does sound like it.
Now it's echoing.
Yeah. The TV on.
You know, right?
No.
It just started.
Oh,
Yeah, but we're feeding back our own audio back into the room instead of just into the Zoom.
So,
So on the mixer that you have there, you gotta not output to the local room speakers, just to the stream.
so Rob and Attorney Maitland, do you have,
that's working.
It's better now.
Okay.
Okay, thanks for the concert, but we'll go forward here.
Not really bad.
That's not really better.
All right, can we got it under control now?
I don't think so.
I don't think so.
Well, we'll let them speak and then we'll see how it goes.
Okay.
You're echoing, well, everybody is echoing to the whole room. We don't have to speak.
Good evening, Mr. Chairman and members of the board, Mr. McCarthy. How does that sound?
Yeah, it
Can you
sounds,
hear me?
Yes.
Okay.
Almost better. Oh, that was loud. That was loud.
Rich, maybe you need to mute your Zoom.
That could be.
Where's Betsy when we need her?
Exactly. I was just going to say Betsy goes away and everything falls apart.
whoa, wait, we got it.
Yay!
Losing it again.
It's bet.
Don't raise the lights. She can't hear us, we're muted now.
Okay, now I can hear you. I just can't hear you, Richard. But yes, okay, can you hear me now? Is this okay?
Yes.
All right. Okay, the matters before you this evening are really just housekeeping. At some point in time, Rob reconfigured Lot 9, which is his home parcel, plus some other parcels in the subdivision, and it became Lot 9A. It's in essence the same lot, just been a slight reconfiguration. And this lot was exempted from the affordable housing covenant, as you might recall, because it was his home lot. But of course, we identified it in that covenant as Lot 9. So because technically it's not exempted from the affordable housing covenant because it's Lot 9A, not Lot 9, we need a release of Lot 9A. I just felt that was the easiest thing to do rather than go back and amend the decision, because that's what you've done on all the other affordable housing lots, and it accomplishes the same thing. What we need to do is clear the title to make sure that 9A is not impacted from the subdivision. So that is the release that I have prepared and proposed to the board for consideration. Simply releasing Lot 9A, which if it's remained Lot 9, we wouldn't have to do this. But because of the reconfiguration, we need to do it. It's a very similar issue with the amendment that we had done some time ago back in June when we amended the special permit decision, when we talked about a revision of the impervious coverage for the lots. Again, Lot 9 was exempted from that decision because it had far more land than the other open space lots. But because we identified that as Lot 9, and it is now Lot 9A, we have to do the housekeeping to clear the title. It's a specifically technical matter on these two items before you this evening. And we do have a conveyance of the lot going forward. And I would ask that the board votes to approve both the amendment to the modification of the special permit decision and the release both lot 9A from both of these covenants so the title is cleared. There's also, unrelated to this, and perhaps I'll defer to Mr. Kane on this, he wishes to substitute the tripartite agreement for a surety bond, and he's working on the paperwork for that, which I believe he has provided to Mr. McCarthy. And it's my understanding that that needs to go before town council, but we simply sort of wanted to get the process started because he would like to substitute the performance bond with the surety company for the tripartite agreement with Rockland Trust Company.
Okay, let's take them one at a time, Rich.
packet with the green one.
Probably here.
It's in the green one right in front of you, Walter.
The green folder, yeah.
Oh, the green folder, okay. Number of signatures, okay. We have here the release 9A and the release of 9. So let me read these to the board as she has prepared them. Okay, this is Town of Norfolk. Grantee is the Norway Farms Drive LLC. Locus is 9 Norway Farms Drive, Norfolk, Mass. Lot number 5. At a meeting of the Planning Board of the Town of Norfolk held on August 17th, 2021, it was voted to release Lot 5, parentheses, 9 Norway Farms Drive, close parentheses, as shown on a subdivision plan entitled Open Space Preservation Development, Norway Farms, dated September 26, 2017. Last revised March 9th, 2018, and filed with the Norfolk County Registry of Deeds in Plan Book 673, pages 90 to 94. From the operation of a covenant dated August 13th, 2019, and recorded with the Norfolk Registry of Deeds in Book 37556, page 468. This release acknowledges payments required by the special permit of the Planning Board of the Town of Norfolk dated August 5th, 2019, and recorded in Book 37553, page 400 of said Registry of Deeds. Said release shall not, however, affect or impair the rights of security of grantor in the remaining of the lots pursuant to said covenant and special permit which have not been released to date. Witness our hands upon this seal this 17th day of August 2021, signed by the members of the board. So that's the release of 9 Norway Farms. And the other one, it probably reads very similarly, but I'll read it all. Also, it's Grantor, Town of Norfolk, Grantee, Norfolk, Norway Farms Drive LLC, Locus, Lot 9A, 12 Norway Farms Drive, Norfolk, Massachusetts, 02056. At a meeting of the Planning Board of the Town of Norfolk held on August 17th, 2021, it was voted to release Lot 9A, parentheses, 12 Norway Farms Drive, formerly shown, close parentheses, formerly shown as Lot 9 on a subdivision plan entitled Open Space Preservation Development Norway Farms, dated September 26, 2017, last revised March 9, 2018, and filed with the Norfolk County Registry of Deeds in Plan Book 673, pages 90 to 94, from the operation of a covenant dated August 13, 2019, and recorded with the Norfolk Registry of Deeds in Book 37556, page 468. Said release shall not, however, affect or impair the rights of security of grantor remaining of the lots pursuant to said covenant and special permit which have not been released to date. Witness our hands upon this seal the 17th day of August 2020, signed by the Planning Board. So that's what she's requesting to do, sign these 2 releases. Questions and discussion from the Planning Board members? Okay, then Rich?
Elizabeth's trying to speak.
Elizabeth's trying to speak, okay.
You're muted.
I'm muted?
Oh, no, go ahead.
Okay.
Okay. I'm not quite certain where the first release that you read, Mr. Chairman, came from. I prepared the second release for Lot 9A.
Yeah.
We don't need a release for Lot 9. There is no longer a Lot 9.
Okay.
And even if there was a Lot 9, by the terms of the covenant, it's exempted. So we would not need a release for Lot 9.
Okay.
The only reason we need a release is because it's now Lot 9A.
Yeah.
So I'm not sure where that first document came from.
I don't know either, but we won't sign it if you don't want us to.
That's
No,
the
I only need the
affordable
one
lot?
for Lot 9A, sir.
5.
Yes, that's with the
It's,
first.
yeah, the first one's lot 5, 9 Norway Farm Drive, which is the affordable.
Yeah, the first document is Lot 5, which is street number
Number
9,
Yeah.
Norway Farm Drive.
Right.
And the second one is Lot 9A, which is street number 12. 12.
Yes.
Yeah. So the,
Lot 5A was already signed and recorded. That release has already been done.
This one, yeah.
On the affordable?
Lot 5.
The
On the
affordable lot.
affordable?
We don't have an affordable lot. We did a payment in lieu
Yeah.
of an affordable lot.
That's right,
Do you
that's right,
recall?
that's right, yes.
Right, but,
So Lot 5 has already been released and conveyed.
That's right,
The only one
Okay.
before you this evening is Lot 9A.
yeah. So how did this one get in the folder then?
let me just,
By error, that's all?
no, let's hold on one moment. I thought, so you made the payment for lot 5.
Oh, I'm sorry, okay. I didn't
Yes,
realize that
yes.
hadn't
No,
been
no, it's-
processed yet.
Received, yeah.
it
It's
hasn't
all
been
right.
processed yet.
Yeah,
I'm
so,
sorry.
yeah, so they did make the payment for lot 5
Yeah,
under the affordable, under the
Right.
payment
in
schedule.
lieu of, right?
In lieu of. So this is the release from that covenant,
Yes.
right?
I'm sorry, I didn't realize you had two on.
Yeah.
And yes, if that has not yet been processed for Lot 5, that was the last lot that was conveyed last
So
month.
both need to
That
be.
payment has been
Yes.
made, so that should be signed as well. My apologies.
That's
All
right.
right, okay.
Yep, both need to be.
All right. Well,
We're still willing to sign.
I think so.
I'm good.
So I
All
need
right.
you to sign both of those,
Yeah, I
please.
understand. All right,
My
so-
mistake.
All right, fair enough. Chair will entertain a motion to sign the two releases for Norway Farm, Lot 5, 9 Norway Farm, and Lot 9A, 12 Norway Farm Drive. Do we have a motion to that effect? Do we have a second?
Second.
All those in favor say aye.
Aye.
All right, so we will sign these and proceed as we go along. Now, another issue, but let's,
Yeah, in terms of switching surety, as Attorney Maitland mentioned, we will, and I already emailed Mr. Kane that I'll forward that to town council to review, which is our typical process we do for surety bonds. And then, were you able to find out, I think there are still some lots on the covenant anyway, isn't there, in this?
Yes, we think there are probably, where's my numbers here? Rob and I went over this earlier this evening. There are now 5 lots under the covenant
Okay.
that we've not requested release on as yet. So there are 5 lots remaining under the covenant.
Okay, so based on that we have 5 lots under covenant, and they're gonna switch from the tripartite agreement to a surety bond. At this time, we don't need to have a revisiting of the amount that's been established by the bonding company, because there's more than adequate security between those two combinations.
based on history, I'd like to have the lawyers make sure that after this 2-year surety bond time expires, we want to make sure there's a continuation process in there where we don't automatically have to go get this thing re-signed.
Correct,
To
yes.
make sure this thing
Yep.
automatically renews until all the
Yes.
monies are paid off.
Absolutely, I agree.
And you
Yep.
should have that on your ticker too, so when it comes up, you're aware.
Yes,
Right,
correct.
going
yeah.
from past history.
Yes. I agree. So for tonight, it's just a matter of forwarding it to town council to verify everything's there, and then you can come back at the meeting in September to vote on it.
Okay,
Okay.
Make sense?
yep. So, we don't need a motion to that effect?
No, not really.
No, okay.
I think we're okay.
All right,
All right?
yeah, very good.
Mr. Chairman, there's still one other item that I referenced at the very beginning. Because you had that second document for the lot release from the affordable housing, I think it got a little skewed. But the other document that I had sent was an amendment to the modification of the special permit decision. Again, because
yes,
lot
right.
9 is identified as lot 9 and it's now lot 9A. It's a housekeeping issue just to clear the title. And I had sent across a proposed amendment to that modification of the decision to address that issue and that issue alone.
Do we
So
have
if
that,
we could
do we have that in
have that
front of us,
considered
Rich?
as well.
Well, I know it was sent along. I think when I landed back from vacation, I don't think I have it in here. Let's see. Well, hold on a minute. Let me just look. know it was sent, I saw it in the email.
Yeah, I think I sent it to you maybe a day after I sent the covenant release on 9A.
Yeah. I think,
Can I send that again? Would that help?
yeah, for some of the members.
Yeah, I can't, I mean, I don't know, I'm gonna try to do this. I may lose you, but I'll come right back in. If I do, I'm not so good at this. But let me see if I can find it quickly, and I'll email it to you straight away. Just my screen, I guess, is gonna change. Let's see here.
You all have your phones with you, right? So I'm gonna see if I can.
Okay, oops. Okay, I'm sending that without any text in the message, Richard. I'm just sending the document itself. It's a simple one-page document, hopefully. It won't be
Alright,
too
then I'll-
bad.
Okay, and then I'll just forward it to the board members as soon as I get it.
Okay.
So,
It should have sent.
forward it now.
Oh,
Always watching out for this caps on it. Yeah.
It's a short 3 paragraphs. Would you like me to read it, Richard?
We're gonna, just give me a second.
Oh, sure.
All right, I just sent it to you. Look on your, I mean, I suppose I can read it.
got it.
Word file?
Got a, yeah, Word document, proposed amendment.
Yes.
You want was to read it out loud?
I don't think I have it, Rich. Yeah, okay.
Just housekeeping, that's all.
Yeah, okay, yep, that's right.
You can vote in this like this, Rich?
Yeah. I can, I could go print it off if you want, real quick. Are you okay to vote on
Sign
it?
To sign it, you're saying?
Yeah, to vote on it, and then,
Yeah, we need a printed copy to sign, obviously.
yeah, I'll print it to sign it.
Yeah.
Well, Betsy's she has to notarize it anyway, so we can, you can just vote it and then she'll come in and,
Okay.
you can come in and sign it and
Yeah,
she'll
fair
notarize
enough.
it, so.
Okay.
So you wanna just vote it, and that'd be great.
Yep.
All right, so, Chair will entertain a motion to approve the request for a modification of the special permit for Norway Farms subdivision. We have a date or anything on
Number
it?
2020-04.
Number 2020-04.
So moved.
We have a motion, we have a second.
Second.
All right, all in favor, say aye.
Aye.
Opposed? It is a unanimous vote.
Thank you very much, gentlemen.
You're welcome. Have a good evening.
Thank you, you all too. Signing out.
Thank you.
Thank you.
Okay, Rich, we'll discuss potential fall meeting zoning changes on the floodplain bylaw.
Yes. Oh, no, we'll skip, we'll defer to that. So I have Blair Crane via Zoom. I have Bill Buckley, who is the engineer representing
Oh, they want to talk about the salt shed.
Salt Shed, yep.
Okay.
And then have Town Administrator Blythe Robinson online.
Okay, sure.
To
Well,
talk about the,
Salty
salt shed.
subject, let's go.
all right. So essentially, the salt shed was damaged in snowstorm, I guess, or was it wind? It's been damaged, so it needs to be replaced. And it does require site plan approval through the planning board. So tonight is just more of, it's an introductory, informal presentation to make you aware of it. It is in terms of hopefully try to fast track this along, because we'll need to, the idea is hopefully makes one more winter and then get it constructed next spring, so then afterwards we're in solid shape.
Yep.
The shed is going to be, in terms of a better design and option for DPW. And I have actually an aerial image of, with an outline of what shape it will look like. Essentially, it's going in the same place that the existing one is already. I do have so Bill Buckley does have a presentation I forwarded to the board, that we can go through. Just intro. They will be required to get a special permit from the Zoning Board of Appeals for municipal use in the residential zone. They'll have to apply that. That'll be something that they'll be working towards for October. The target is to come before the planning board for this project October. I wanted to just kind of touch base, give you a kind of a preview beforehand, before coming in. They are going to be requesting a required parking space reduction. They do have parking on the site, but to fully build out the parking based on the bylaw, will require a lot more parking on there. So that is one additional permit that they'll come before you. So I'm not gonna take away all the thunder on the presentation. If you want to, I'll defer to Bill. You want to pick it up from there?
Sure. Good evening, ladies and gentlemen. My name is Bill Buckley. I work for Bay Colony Group. And I'm going to share my screen here to throw up the PowerPoint that Rich was just showing you.
All right, so I'll just
You
need
could-
to hold on.
Let me share.
Yep. I'll make you co-host. Go ahead, you should have it now.
Okay, good evening. So I think everybody's familiar with the site. This is at the end of Medway Branch Road, 33. Medway Branch is the DPW yard. And this is the lot. It's about a little over 10 acres. And it's across from the transfer station. You can see that on the right side here is Barnstable Road, excuse me, and on the south is Wellfleet Drive. I'm gonna just zoom up in here to make it a little easy to look at. So this is the existing facility, parking over here on the right side. There's a fueling facility here to the north as you come in the main entrance. This is the existing salt shed. It's roughly 75 by 40. This is an outdoor storage area, and you can see the area of the site that's currently being used. So what they want to do is remove the existing stall shed, installing a new one. As Rich said, the existing facility's outlived its useful life. The roof has failed. The volume's inadequate, which means that requires extra trips for the tractor trailers to drop off salt with the 10-wheelers. The doorway is too small to allow access for the drop-off, so then they have to drop it off outside with salt outside, and then load it by bucket into the structure, which creates more trips, more noise, more light. And the ramp on the side of the building is also not an optimum location. So the new facility will increase in size, which of course will decrease the number of trailer trips, replenish it, It'll have a larger doorway to allow vehicles to drive into and dump in the facility. Again, you won't have to bucket the material into it. One of the things I'll show you in a moment here is we recognize that we have neighbors, residential neighbors to the south on Wellfleet Drive. So what we're proposing is instead of just trees or something like that, we're talking about putting in a wood barrier, something like you'd see next to a highway, not as large. This one would be about 15 feet high and about 144 feet long in order to create a barrier between the homes next to the salt shed and the home itself. This area, again, I'm going to show you in a moment, it's really already completely disturbed. It's already a salt shed, and there's not a blade of grass in sight. It is gravel, and again, I'm going to show you the minimum. So really, we're talking about de minimis increase in any type of runoff, if any at all. So here is a sketch of the facility, kind of zoomed in. Again, I'm going to zoom in on it. This will be the new salt shed. You can see the old one underneath it. This area down here, this is the area where the solid wood barrier will be located. It's along the edge of the area that's already been disturbed. It's not like we'll be cutting trees down to go in there. It'll be about 30 feet inside the property line, again, along the back of the area that's currently being used. And what that purpose of that is, when vehicles are pulling in, they'll come in this direction. They pull in, they back in, and so you'll get some glare and noise, and what that will do is that will be ameliorated by the presence of the barriers. And as I said before, you can see this whole area. I know it's hard to see the shade over here, but again, this is all graveled area or paved in the front or the building itself. This is what an end view of the building is going to look like. It's about 56 feet wide, and it's about 80 feet long. We were playing with the distance, with the length of it, but it's 56 feet wide. You can see the height of it here and the width. And here's a picture of what the building actually looks like. It's a fabric building with a metal skeleton on the ground. And you see these are DPW yards, or a lot of times you see them in Mass DOT yards, for salt. So as Rich talked about, these are the permits we need. We need a site plan approval from the planning board, a special permit for parking reduction, going by the square footage of the existing facility and the new facility. We would need 63 spaces. There are currently 25 spaces on the lot, which are adequate. You won't be adding anything to them. There's no increase in personnel. There's a slight increase in the number of, in the square footage, but we don't project any increase in parking requirements. Zoning Board of Appeals, special permit for use, and it's municipal use allowed by special permit, which is in all zones. A couple of waivers we'll be requesting, traffic congestion control and analysis. Again, we don't believe that is really necessary. It'd be difficult for us to project anyways, because the number of trips has to do with the weather. Site lighting plan, we would do a site lighting plan for any site lighting in the area of the new facility, but we wouldn't be going out throughout the whole facility over the existing building, trying to figure out types of lights and heights and modeling that. But we would be doing one in the area of the new facility. And then, as Rich pointed out, one of the things we're looking at is we're under a time constraint here. So we would ask the board to consider no peer review, again, because that adds time to it. And as we talked about, most of the time you see in a peer review is stormwater. There's almost no increase in stormwater here, and what fractional increase there will be, we would handle it around the facility anyways. So that's it. I know you have a full agenda. Questions, comments, recommendations?
I think what I heard you say is the current floor in the existing salt shed is gravel. Is that right?
The current floor is pavement at this time.
Pavement, okay. And what's the plan for the floor in the new salt shed?
So the existing floor is pavement, but it's cracked and has certainly taken a beating over the years. So the plan would be to demolish the existing building, regrade the slope that's there, because I would like it to be a little more of a flat surface for running equipment inside, and then we would repave it before the building was set on top of it.
So all the salt would be contained within the building and on a paved floor, not?
Correct.
Okay, all right, yep. Thank you. Any questions from board members?
What would, the peer review question is, to eliminate peer reviews, how much, are you just concerned of a waste of time, it sounded like, and you're in a hurry? I don't think Beta would, maybe there's just not that much for them to evaluate. Would they be evaluating the structure itself?
Not the structure itself, they would really be evaluating, they were more of a site.
Just a site?
So, I'm not sure, and, although in this particular case, it's already existing salt shed, it's
Yeah.
within the existing facility, so
Okay.
I'm not sure the value necessarily you would,
Yeah.
in this instance, would provide.
There is no runoff, there is no concern, the buffer's got smaller, obviously, but you have sound barriers now at the backside of the property.
Yeah, so they're actually making improvements to the buffering that's there today, as part of it.
And we didn't need a hearing of any type with neighbors contacted?
No, you will be,
We
they
will,
will, yeah,
okay.
so
Yes.
so this is really just informal to give you a primer of what's coming forward, but it will be advertised and will be noticed to butters within, same process.
Okay.
How close is the nearest residential home? Right over the fence, right over the line.
Yeah, that buffer's down to what, where the barrier's being put up?
So you're able to,
I think you said it was, barrier was 30 feet from the property line?
Yes.
See the
Orange line to the
orange
yellow line.
line is the barrier, and the yellow line is the property line, the house right there.
Where's the new shed gonna go to?
There's
Dark red line.
Dark red, it goes to the dark red? Yeah,
Yeah.
up top there.
so no closer than it is to the rear,
Right now.
it's going closer to the
They're adding
landfill
front.
side.
Yeah, to
Right.
the front and the side.
So those lots, what is that dimension, Bill, off the property line?
And so the trucks are entering from the rear by the sound barrier?
The trucks enter from the north, right now they enter from the north. So the heads to the trucks while they're being loaded on that ramp to the west. The headlights face the residents that are to the south, and then they pull out through there. We have tried to be good neighbors over the past couple of years and do what we can to minimize backup alarms, times of the day, but obviously Mother Nature kind of sets our schedule. But we do what we can to minimize our impact.
You're probably looking at about maybe 120 feet from the property line to the, this area in here, property line to the building. And that's another 30 there.
Okay.
Okay.
And this is still the best location for a salt shed on that parcel?
Yes, I believe so.
How did you determine the length of the barrier that's shown in orange? It seems like it's, I don't know, it could be extended, so I'm just asking why it was determined to be that length.
Sure. So what we did is, if you look at where this is and you look where the homes are, these are the two homes that are most impacted. You can see where trucks coming this way are coming like that. That would be there, where their glare would be for a light, and if the truck's working in this area there. So that's how we came up 144. It's going to be probably 12-foot section, so that's kind of where we came with. Along this area here, there's already a line of trees that I think were planted when the expansion of the DPW garage was done back in 2000s, I think. So that's what we're just trying to do, is kind of pick it up there and go down forward.
addition of the wall, is that our response to previous complaints, or is that us being good neighbors?
I think a little bit of both. I think, obviously, we're cognizant of the fact that we are close. But I think it's a good gesture on our behalf to try to minimize that while still serving the public trust.
Topography doesn't change at all, though, although there's a little bit of misalignment on the existing cracked base under the shed right now. The remaining topography, even where you're clearing to put the barrier in, none of that changes. It's all the same. So runoff isn't really changing to any degree.
Correct.
How many acres is the site that the DPW has down there on Medway Branch?
It is about 10 point, I think it's either 10 acres or 10.8. We haven't done a full survey yet.
Did you ever investigate any other possible locations for this, now that you're tearing this down and rebuilding, that wouldn't be as close to residents?
Let me go back and show you, let me go back here.
I mean, now that you're gonna build it from scratch, it might be a nice idea just to make sure that that's the optimal place.
I want to show you, so you can see where this is.
All those houses go along.
This is the area.
No, one's as bad as another.
They're right, the homes are all along the back lot line. This area is not to be cleared.
Yeah, I think John's probably saying where you currently store the wood chips on the way into the town woods. There's a lot more depth there, say it's closer to the, well, because your property extends almost up to the solar field. It does. So.
Right, when you get out toward the landfill and up on the backside, you start to get into the landfill area where the water supply, where there's monitoring wells all throughout there, so that it becomes an issue with stormwater and environmental hazards.
Salt storage is not allowed in the water resource protection zone.
Any other questions from board members? Okay, so we will, as I understand it, we will entertain a site plan modification sometime in
October, yeah.
In our October meeting.
Any further thoughts on the peer review, no peer review? What,
I think we should do a peer review.
I think we should do a peer review.
With the police station.
Yeah.
Left to a nightmare.
Yeah, I think we should do it. It's not a big deal. I think this is a big change, and I don't think Beta will take a long time to do it. I would anticipate one meeting interval. You know, we get the application, we get the drawings, we have a discussion, we send it off to Beta, and Beta returns the response, and we discuss that at the next meeting. And so I don't see a big change. That, with or without a peer review, it's probably going to take 2 meetings to approve this.
okay. All right, I'll get it to them at a time so that
Yeah, it's no big deal.
Prepared.
I'd like to have it, yeah, I think
Okay.
it protects the town, it really does. Well, the nefarious things that Blair's doing, we'll uncover them, right?
Who knows what's out there?
Okay, thank you very much, fellas and ladies. Anything else that you'd like to present this evening on that?
Not at all. Thank you, everybody for your time, and look forward to coming before you again in October.
Okay, thanks. See you.
Thank you.
Thank you.
Thanks.
Have a good night. All right, let's see. Now we get to the floodplain review, right?
It's really just asking, as I summarized to the board, is just a placeholder for the fall, for the floodplain. Bob, the building department's going through it, and has some comments, so it's really just to get it submitted to the warrant. What I would do is get his comments back, and then at the September meeting, we would go through it, you know, what, all the all the different changes to it. But as I mentioned before, this is really in response to FEMA, which is, goes through the State Department of Conservation and Resources, what administers the floodplain program for Massachusetts. And with all the flooding and hurricanes and storms and so forth, they've pushed down to the local level to have certain requirement, model bylaws that municipalities need to adopt. So there is a requirement in terms of us to do this. So we do this, we leave ourselves exposed in terms of if we did have a catastrophic event, potential not getting FEMA reimbursement. And those happen in the winter too, right? So
Sure.
it's all those. But anyway, this is just to ask the board to sponsor it to go to the fall town meeting.
Yep,
But I'm gonna give you the details, so you're just a placeholder for now.
okay.
All right, that's,
So when do you think we'll see the language changes for this?
you have it right now, it might not change that much in the packet.
Okay.
So if you wanna just look through it now, it might not change that much, but, so you have kind of the framework of what it is. So essentially what I did, I took our existing floodplain bylaw and then took the requirements that are in the model bylaw and tried to marry those together. So you can see the track changes in there. So some of it is a little bit of reorganization that we already have, and then there's some new requirements in there. But we can, you'll, between strike-through and change-outs, you'll see the changes
Yep,
on it.
okay. All right, thank you, Rich. Next item is discuss construction requirements prior to release of lots. John volunteered to come up with some set of requirements that the board should enforce before releasing lots in a development, to keep the developer honest and keep us from chasing these developers to get things done, which we have been doing too much of. And he's got a draft of...
I got an Apple Note, and of course, with my technical inability, I wasn't able to look it to Rich without giving my Apple ID up. So I thought I'd just go over the items. Right, this is an open template, so we can dock this up how you see fit. But maybe you can jot some of these things down in the main sections. There's not a lot. My purpose was to try to protect the town, so when the end comes, we're not stuck with everything. And also respect the person developing's cash flow, so they wouldn't get crippled needlessly for tying them up. So this is what I come up with. As far as phase one, the roadway, base coat, and drainage should be installed and functional. That is part of our current regulations. An as-built plan on the drainage and road base coat should be done at that time. And the thing is, when you go to finish a road, if the road is in the right section on private property, wrong elevation, you'd rather not know when the road's being finished. We should know right away to eliminate a whole bunch of problems. Anybody wise would do that because our as-built is accumulated costs, so it's not like you're winning money by doing an extra step. You're doing it at the same time. So now the town would be assured the road's in the right spot, it's the right elevation, and the drainage works. And that, to me, is probably the biggest key thing. Our rules right now talk for all of the deeds to the open space and the easements should be turned over to the town before any lots are released. And again, the current rule we changed 4 years ago. And any fees due for open space should be paid. Again, some past history. At that time of phase one, I have down here that we should release 50% of the outstanding lots, rounding up the fraction. So for example, if you have a 5-lot subdivision, you would be releasing 2.5 up to 3 lots, right? A 10-lot subdivision, you're releasing 5. So after the roadway and drainage are in working as built, we go to phase 2. Phase 2 required task would be to complete any infrastructure, which is really big because stone walls that are required, retaining walls, guardrails, they're very expensive. And nobody really wants to do that till the end. So with a lot of these things, we end up at the end getting stuck, dicking around and having this not done. So I thought that completing all that infrastructure, walls, guardrails, lights, base cut on the sidewalks, and an as-built on the sidewalk. That ensures the sidewalks are in, they're all in the right space. Update the bond or the surety for fair market value. So if this project for phase 2 is taking 4 years, we want to make sure that the bond is still relative to market value so we don't fall behind. Again, make sure our fees for the open space lots are paid. The tricky part of phase 2 and the lot release, what we're gonna do is reserve 15% of the lots till the end and release in phase 2 the difference. Let me give you the reason. On a 5-lot subdivision, if we released initially 3, and you've got 2 left, and we release 35%, if you do the percentages right, you're talking about releasing the other 2 with nothing left. This way, if you withhold the 15% of the end, so in this case, 15% of a 5-lot subdivision would be 1, which means in the phase 2, right, you'd get 1 lot release. On a bigger subdivision, 10 lots, it becomes more equitable. So in a 10-lot subdivision, we're having 2 lots at the end to be held. And what we learned is the only real salvation we have, or anybody developing, or everybody normally does everything, makes the money and leaves, is to have lots. That saved us the Personal Pond subdivision, and there's no other way that really you lock in and make this thing secure for the town. At the same time, the bond is also still in place. The bond based on what's going on. The balance of the lots would be done in phase 3 after it's completed. In phase 3, the required task are complete all the landscaping, including street trees, grass strips, cul-de-sacs, detention basins, swales, and any other miscellaneous landscaping areas required by the plan. Install the bounds, and again, depending on the time frame, update the surety. After that, the balance of the lots would be released. The subdivision then, to finish it up, right, with the lots gone and only the bond in place, we'd have the whole subdivision as built except for the finished road and sidewalk. The drainage structures would be done. So what would be left is to put the finish coat on the road and the sidewalks, which really, if it came to that, with the bond money, is an easy task for a DPW. Raising the drainage structures, cleaning the basins, final cleanup, and to complete the as-built, which is basically just being the as-built on the top coat of the sidewalk and the driveway. For everything else will be done. So if somebody gets to the point that they have no lots left, we've got a bond with probably the most simple task for the DPW to perform. So I just threw these down as a template where you guys are welcome to go add or deduct or whatever. But I don't think with these requirements we're going to end up hurting anybody cash flow wise as far as their project. But the problem is all of the expenses in the subdivision are normally left till the end. And the costs are so much at the end and the lots are sold, that's when we start to fight over how to get it done. And that's what ends up getting us in court or spending money to finish the project. This way here, really, I don't see how the town could lose any money. But anyways, I'll forward this to Rich, so perhaps he can send it out to you folks and we can discuss it with it in front of you, right, the next meeting. Give you time to look at it and decide what you want to adjust or tweak or whatever, and we'll go from there.
Good, thank you, John. I think
Sounds good, yeah.
Okay, that's,
Is there anything similar that other towns do?
I'm not sure. But I know most people, why would you not as-built when you go? You wait till the end, it's just, it makes no sense because
Right.
it's not a cumulative cost. There's no reason why you would never not do that.
Yeah, no, I completely agree.
But then
I think it's a
again,
great plan.
99% of the folks out there do not do it.
Yeah. My intent in asking is just to ensure that we didn't miss anything else. Yeah.
well, I tell you, if we follow something like this, it's going to save a lot of ulcers. We have spent countless hours chasing developers to finish these developments.
It's gonna make the residents happier that live in them.
Oh, yeah, yeah, countless.
And all these tasks fall into place, so they could be done consecutively without not messing up the construction site, right? So when they've got the last 15% of the lots, whether it be one or two, whatever, we're getting the landscaping all out of the way. And believe me, each lot is precious, so they're gonna wanna do the landscaping at the proper time and.
And if they know about this up front, there's no excuse. I mean, and we have the leverage. We have lot release as the leverage.
Right, that's the key.
Yeah.
The planning boards in the past, and some of these things are in the rules, have played the nice guys and released lots on some of these things before things are done. And the nightmare does come at the end. I'm not gonna name any subdivisions or any people, but there's a long history. So the planning board really has to look at this regulation, if it does in fact become one, and really hold to it, because once something goes by, right, it's really hard to get it back, so.
And you know, as you said, in history, if you're being a good guy and you're dealing with a good guy, it's not a problem. But oftentimes you're not dealing, the guy who wants to make a buck and run.
The business is different. Most stuff is, the expensive stuff is stuff at the end, right? We can send this over to the DPW, right?
Yes,
I
And let
agree.
them,
Yep.
let them take a look at it and see. So we get all the
Yeah.
comments back, and maybe we come up with, one comprehensive, list.
And we have it, obviously we have it on tape as well, what you just said, so.
Yeah, but we'll work to put it to paper and then send it around and send it to DPW.
Because we're
for-
gonna be having the subdivision up off of Lawrence Street that applied before and withdrew.
Cranberry Heights.
Cranberry Heights, and they'll be coming back, and they have a 24 lot subdivision. So the
Yeah.
consequences become greater when you've got, that much infrastructure that's being done, so. That's it for me.
Good, thank you, John.
Thank you, John.
Very helpful.
So one thing I did hand out late in front of you was a zoning change initiated by the building department to the sign bylaw, which,
That's this thing, you got it?
yeah.
Yeah.
The purpose of that would be to allow for the town to be able to place, really, those essentially LCD,
The mobile signs? Just-
not mobile, it would be
Oh.
permanent, but it would be controllable to be able to display, announce, community event, activities, town meeting, different things for people, with the intent to be able to put it on, here in the center of town.
Like on the kiosks.
Yeah. Like a kiosk, but it'd be the modern day kiosk in terms of,
Like one of those things you see at the mall when you want to know where you're going.
yeah, but it would actually, yes. I mean, basically I would describe it almost like an LCD, right?
So is this something that you'd walk up in and use, or drive
No,
by?
you would just drive by it.
Okay.
Yeah.
It's like
I
a
mean,
sandwich board.
It's like a sandwich board, but it allowed to be able to put messages,
That little structure by Walgreens, that little enclosed shed there, so to speak, that initially was to be to post town events.
Yeah.
I always wondered what that was for.
Yeah.
There you go.
So we kind of
Looked like a little
advanced.
bus stop.
Little bus
kinda.
stop,
Yeah.
So the idea is advanced to the modern technology world that allows to be able to, have something that visible and readable, and so.
See that? I didn't get one.
Oh, you should have it.
I-
No?
No?
My bad if I didn't.
There's an extra one here. Here.
Oh,
Oh,
okay,
all right. So anyway, I wanted to, I'll speak to Bob. I think he might ask for your co-sponsorship on that. But,
He says no moving or animated signs, huh?
yes.
He doesn't like them.
No, yeah, so it'd be static. It would be, it's not,
What's wrong with moving signs?
well, sometimes it could be,
I think he's just trying to avoid it being a video. Like,
yeah, video. It could be distracting.
Well, the only thing that's changing is the exception, what's in bold, so that's already existing.
Yeah.
So he's saying it's
Yeah,
fine
I
for the
understand that.
municipality to use flashing and intermittent lights.
And it only applies to town properties?
That's it. Yeah.
Okay.
Yep. So we so to speak, testing the waters, at least for ourselves, and then,
Okay.
and see how it goes. And then quickly, last two items, as I said, or mentioned in the synopsis for the meeting, look to have a meeting in October, a hybrid meeting, for a presentation on the wastewater master plan.
Okay.
Or, we could figure out a date and time, for that. And then in terms of Southwood, there isn't, too much of an update. We're just waiting to hear back on the grant that we applied for on the planning side of things. They were, one target was August 2nd for them to respond to comments from the public involvement plan. I have not seen any of those comments. There hasn't been anything posted on the DEP website as of yet, but,
And you've tried to contact them?
no, I haven't contacted them, but, it's really kind of running through the DEP, but they didn't, their timeframe to respond, I don't know if there's any penalty for meeting those timeframes, to be honest, that would have to find out, but they didn't, there hasn't been anything posted as of yet, so, just as an FYI.
Okay.
And then, like I said, we have, 2 sessions on master planning.
Yep.
One this Thursday night, 6:30, via Zoom, so you can do it from your home. You don't need to be here.
Are you gonna be here?
I'm not gonna be here either. I'm gonna be home. Everything's
No one's
gonna be.
here, so.
No one's gonna be here. It's all gonna be, it's all gonna be via Zoom.
Okay.
Okay.
And then the second one is September 23rd. So, and it's open, it's open to all residents, and it's open. And actually, some other communities, they might hop on too.
Oh,
Because
okay.
Citizen Planning Training Collaborative does these planning sessions for communities on a variety of topics. And we can, as we go along, we could actually probably get other topics if the board wants to for training, bring in a subject expert, and we can do them. Normally, before this, they're all held in person, obviously. But now with Zoom, it actually makes it a lot nicer to be able to attend these kind of things.
It does,
So-
it makes it more convenient.
Yeah, it does, it
and
does.
Can reach further.
Yeah, so, anyway, that's just an FYI.
Okay.
Other than that, that's all I had.
So last thing we
Well,
have-
you have the minutes,
Yeah.
right, yeah, minutes, sorry.
yeah.
So I'll make a motion to review and approve the minutes from our July 15th, 2021 meeting.
Have a second?
Second.
All right, all in favor, say aye.
Aye.
The meeting minutes are approved. Do we have any other business this evening?
I don't.
Hearing none. Chair will
make
entertain
a
a
motion
motion
to
to
adjourn.
adjourn. Right, a second. Do we have a second?
Second.
All in favor, say aye.
Aye.
We are adjourned. Thank you very
Thank
much,
you.
gentlemen.
Awesome. Thanks, everyone.